This is You and the Law on AM 650. Now back to the show.
Welcome back to You and the Law here on AM 650. Today in studio, Vancouver estate litigation lawyers David Hobbs and Ian Giroday from Hobbs Giroday. And we're learning more about executors and administrators. And Ian Giroday, you talked a little bit about the difference between an executor and an administrator. And in the course of the description, threw a little phrase onto the table that I want to return to. And that is one that occurs in the lives of a lot of British Columbians. In the event of no will, the court will intervene and do this, that, and the other thing you said. I get the feeling that this is a pretty routine occurrence in the courts and in the whole wills and estates sector of law. A lot of people die without a will, correct?
Yes, I suppose that's true. I couldn't put a percentage on it, but there's lots of cases before the court where people are dealing with an intestacy rather than dealing with distribution under a will.
Okay, and in British Columbia, David, we have a formula for that in law, where if you die and you don't have a will to describe how your estate should be divided among whoever, the state, in this case the province of British Columbia, has a formula that is a template, if you will, that is superimposed on your life and your circumstances, correct?
That's correct.
How does it work?
Well, the Act sets out the chain of distribution of your estate rather than you deciding and choosing and declaring in your will how your estate is going to be distributed. Because there's no will, the Act answers that question. So, in the case of you die, you have no will, you have a spouse, and say you have a couple children, then the spouse is going to get, I think it's $65,000, the first $65,000. The spouse is going to get to live in the matrimonial or family home, if there is one.
Okay.
And the spouse is going to get a third of the residue of that estate, and the two children are going to get the other 2/3. And then the Act goes on, well, what if I don't have a spouse? And at a point, your parents will become the people who receive the estate. And if your parents are not alive, then your siblings will receive the estate. And if your siblings are not alive, then your nieces and nephews will receive the estate.
And this
so
is
on.
all a formula. It's
and
all
so
laid out,
it's
right?
all, there's different sections of the Act
Right.
that lay out this chain of events depending on who's alive, who's around, what their status is, and so on. So the legislature writes the will for you, and that's what the Act does.
So, again, if you want to avoid seeing any good come to the horrible spoiled nephews and nieces in your life that you don't want a penny to go to, make sure you have a will and instruct your executor to follow that wish, correct?
Right, and I mean the other thing about the intestacy is there's nobody appointed to be the executor because there's no will, so this word administrator comes into play again. There's going to have to be also the appointment of an administrator, and there may be a fight about who's going to be the administrator.
Right. And just to be clear, Sterling, under the Act, that there's sort of stop points. So if there's spouse and children, they will take the entire estate. It's only if there's no spouse and children do they go to the will makers, or pardon me, the deceased, the non-will makers,
Right.
parents. And only if no spouse, no children, no parents, does it go to brothers and sisters.
Also, that list that David identified, it's quite clear that you really, criteria have to be met at each step.
There's demarcation
Right.
line. The buck stops with the various levels.
Okay.
It doesn't sort of flow to everyone.
All right, now, David, this brings us back to a point that you raised a few minutes ago, and that's the whole matter of revisiting your will in a timely fashion every now and then, because perhaps 10 or 15 or more years ago, when your children were little and you first decided a will would be a really smart idea, well, the kids are now in college or beyond. You haven't changed a syllable of that will, yet your life and your circumstance probably have changed quite dramatically. So as a rule of thumb, David Hobbs, how frequently would you recommend people review their will, revisit, and say just to double check that everything is still on side with what they wanted in the first place?
Well, I would say from a time perspective, probably every 5 to 10 years would be my answer. I don't say that from any particular point of reference. That's just from my own experience and general knowledge.
Right.
But the other thing is any major events in your life. anyone in your close circle who passes away, who remarries, who your relationship with them deteriorates, who develops an addiction, who the relationship is materially changing. If that old relationship is reflected in your wishes and in your will, and now everything has changed, then you need to look at the will and say, is this still how I wish things to unfold if I pass away? And as we all know, there's so many significant things that can happen at a moment's notice in life, and yet do we remember to run back and change our will? Probably not, but we should.
Right. It's probably the last thing that occurs to us because there's so much time spent just dealing with putting out the fire of the moment, correct?
Correct,
Right.
yeah. So, but I would say if you're not mindful enough to be running to check your will every time something unfortunate or different happens, at least every 5 to 10 years, you probably want to have a look. Another example is like people in their 30s or 40s, they may pick an older person that they admire as to their acumen to be their executor.
Right.
So I'm 30, 40, now I'm 50, 60, now that person is 60, 70, 80. Do I want, or I shouldn't say want, but is it appropriate to have a very elderly person have to take on the task of being the administrator of my estate? Probably not appropriate, and it has to be revisited.
And does that happen, Ian, if you decide and you take your partner's recommendation here and review the will and all of a sudden realize that the person that you have identified as your executor is indeed now quite advanced in years, and this may be quite a considerable burden for that person to carry. If you want to change that, you should probably first go to the individual you asked and discuss whether or not they want to go forward with being your executor, or do you just go ahead and change it?
I think it depends on the circumstances, Sterling. It may be perhaps you lived in a different town 30 years ago when you made that will.
Very true.
And you decided that your professional advisor, perhaps your lawyer at that time from that town, should be your executor.
Right.
But that relationship ended 25 years ago. You probably don't need to go back to that person and say, I'm going to change you just get on with appointing someone new. And, just to reiterate this need to revisit your will every now and then, we have wills. We're dealing with wills in our office from the 1950s, the 1960s, the early 1970s, where people are coming into us and saying, well, dear old Aunt Maggie here had left this will, and everyone she left a gift to is gone. They all predeceased her.
Right.
And the other thing that you appreciate is a specific gift that dear Aunt Maggie may have been a very significant gift 30 years ago.
Right.
And now it's a token gift.
Mm-hmm.
And that may not reflect her intention. She may have meant to make a very significant gift to that beneficiary, as reflected in its value 30 years ago.
Right.
So there's lots of good reasons to go, to revisit the will.
So when people come to Hobbs Giroday with some issue regarding a will or an estate, some disposition that is not coming their way, or they're just feeling underserved, or they're being treated unfairly as they see it, is it generally family members? We talk about and just mentioned the fact that the divorce rate is 50%. A lot of people remarry. There are a lot of second groups of children and so on. Is this an area of considerable dispute in your practice?
Yeah, I would say that the traditional family, as we think of it with Leave It to Beaver and that sort of thing, mom, dad, and 3 kids, and nothing has changed over anyone's lifetime. You probably would have fewer disputes in this realm. But in today's world, it's the second spouse, the third spouse, a person who doesn't even realize they're a spouse, but they've been living with the person for 3 or 4 years, and at law they become the spouse, but they don't even think of themselves that way in a legal sense.
Right.
So those people all have rights, and they're competing with children, biological children, maybe the first children of the first marriage, maybe there's children of the first marriage and the second marriage, and so on. So these disparate groups are all contesting with each other as to what should happen vis-a-vis someone's estate that they all had a meaningful relationship with.
And frequently I would think there would be, especially in the case of an older person who has been infirm for a number of years and perhaps living with one of his or her children, the burden of caring for that individual falls generally on the shoulders of the child in whose house that person is living. So the caregiver spending the most time with the ailing parent in the years before the person dies is going to have the most exposure to that individual. Are there incidents, again, in your practice where the caregiver, the other siblings, the other kids are feeling, wait a second, we appreciate that you took care of Dad in his final years, and we don't mind at all that you are acknowledged as such in his will, but to receive everything in the absence of us? I mean, we're still his kids, and we still feel that we should deserve something. And he rewrote the will in the last couple of years and left it all to you by way of saying, thank you for allowing me to burden your life in this way. Is that a common situation?
We're certainly aware of cases which have been decided by our court in the last few years with that very scenario.
Okay.
And
how do they usually get decided, Ian?
Well, wills variation cases are very fact specific. Certainly, as a sort of a general level, one would say the child who spent the time looking after the will maker,
right?
It would not be offensive at all, and in fact, the will maker may owe a greater obligation, what we would call a moral obligation, to that child who looked after them.
Absolutely.
On the other hand, a complete disinheritance for the other children would probably be varied, all other things being equal.
Right.
They
be changed.
Yeah, they would get some variation that would leave them something under the will, just quite likely not as much as the child who did the...
I'm curious, David, how these things work. How do they play out in court? Because let's just carry this one half step further. Let's suppose the other siblings come to you and say, look, Dad just left everything to our oldest sister. We feel unfairly treated here. If you go to court and apply for a variation or a change to the will to include the other siblings, would the daughter, in this case, who was going to get it all, would she hire a lawyer separately to defend her right to get it all?
Definitely. And I was going to add to some of Ian's remarks, taking it down to a practical level, is that the contest, a person may say, well, I was the caregiver, I looked after Mom and Dad, and that's why I get everything, because this is what happened. I mean, the obverse or the converse of that argument is that you were just a manipulative person who positioned yourself to receive everything. So then,
certainly brothers and sisters would be hasty to point that out too.
Yeah, and to decide what the truth is of the matter, you have to get into the nitty-gritty of what life was really like. So if I was the caregiver, what care did I give?
Right.
And can you demonstrate that? And that's where these cases sometimes become very fact-specific and very difficult and very emotional and so on, because you're really questioning the integrity and credibility of people and whether they really were what they say they were, or are they just saying it because they would like all the money.
Mm-hmm.
Yeah.
And that's the difficulty of the area.
Yeah, I was going to say, maybe the reality is they were just freeloading. They moved into Dad's house because they weren't working and they needed the room and board, and really they didn't have much to do with caregiving whatsoever.
And then Dad got sick, and like it or not, they were stuck with making him tea and taking care of him.
And maybe they didn't.
Right.
We run into cases all the time where people are taken to lawyers or notaries, and we're always examining the files of those notaries and lawyers and listening to their stories and so on. But it's a classic situation to take an elderly person to a notary or a lawyer, never met the person before, don't know them, brought by somebody else,
right?
And then they engage in some kind of change to their estate plan, and then you have the whole overlay of dementia and abuse and influence and so on. And it always comes down to, is this what the person really intended? Are they doing this voluntarily, or really are they suffering from either pressure or lack of mental capacity? And this can get into the validity of the change that's been made leaving aside the whole question of varying a will, which is a will that's valid but now is going to be changed for moral and legal reasons.
Interesting stuff. I also wanted to add, just before we take the break here, there are a couple of items in a person's life that don't necessarily become part of their estate automatically after they die. Life insurance is one of those, as are RRSPs. Why would those two money-producing items not be included in a person's estate, David?
Well, when we use the word estate and we talk about wills and so on, we're talking about property that you own when you die. And in effect, it's as if you continue to have an interest in that property after you die. So if I own my house, it's registered in my name,
right.
I die, then that's an asset in my estate. But if I have a life insurance policy and I designate someone as the beneficiary, the minute I die, the beneficiary becomes the owner of the life insurance proceeds, and we don't consider it to be part of the estate because there's no asset in the estate after the person has passed away. That asset is going to someone's benefit via the life insurance policy.
Okay.
Same principle applies to a registered retirement savings plan. That has a designated beneficiary. It goes to that beneficiary. It's not part of the administration of the estate. It's not part of the estate.
But Ian, you have kind of a glint in your eye. Has it come up in your practice that people are offended or put off by the designation of the beneficiary in either a life insurance or an RRSP, and they want to fight that one too?
I can't say that I've actually seen that, but it's not just RRSPs and life insurance designations. It's things like putting real property into joint tenancy ownership,
okay,
with a right of survivorship, or putting bank accounts into joint names with a right of survivorship. We have a lot of disputes about what the true intention of doing that was. Was it an estate planning mechanism to avoid having to pay probate fees
right.
on that asset? Particularly, we see it a lot with real property because it's a very valuable asset.
Sure.
And you avoid probate fees, but the understanding or the arrangement by the will maker was that I'm only doing this to avoid the probate fees, and you're going to hold the beneficial title for the estate and therefore for my beneficiaries under my will.
What we do, Sterling, is we look at the detail of how these changes occur. So you can imagine a circumstance where maybe the notary went to the hospital and the person was very ill and some papers were signed and there wasn't much advice, and the notary was picked by the person who got the benefit of this and
right.
brought to the hospital
right.
and so on and so forth. So
technically they got a signature, but really did the person know what they were signing?
Yeah, so that's a color of a certain kind of event.
Interesting.
You could have another situation where the person making the change chooses their own advisor, goes on their own, fully advised independently, and documents a change they wish to make to their estate, i.e. a gift, a joint tenancy, a life insurance, whatever the transaction might be.
Right.
So all these circumstances have to be looked at.
When we come back on this episode of You and the Law with Ian Giroday and David Hobbs from Hobbs Giroday in Vancouver. Ian, you opened the door ever so beautifully for us moments ago. You talked about probate and probate fees, and so will we after these messages.
There's more of the show still ahead. This is You and the Law on AM 650.